Welcome to the Convenient Forum. My name is John Gogliettino, and I'm your host. This evening, we're changing gears. We're talking to a bankruptcy attorney. And you say, a bankruptcy attorney? Well, there's a lot of angles in this world, and believe me, I heard him speak before a business group, and there's a lot to be gained by this interview. My guest is Andrew G. Balbus. He's an attorney at law here in Danbury. I can't, because of Comcast rules, get into too much detail, but he operates a law firm by that same name. And as is my custom, I'm going to ask him to complete his resume, even though I have some here, but I am not good at public reading, especially with lights. So without further ado, Andy, welcome to the show.
Thank you.
Could you tell us a little bit about your background, the law schools? That's usually the kind of thing when there's a lawyer on.
Sure. Well, I'll explain how I got involved in bankruptcy law and work backwards. I got interested in bankruptcy law about 5 years ago because I saw that the level of debt in the economy, the federal, corporate, and individual debt, was astronomically high, and that the likelihood would be that a lot of debt would have to be repudiated, and debts repudiated in bankruptcy.
That was the height of the mini depression, roughly about 5 years ago.
That's right, and if you compare it to the Great Depression, the level of debt to GDP then was 300% in 1929, at the beginning of the Depression. But the level of debt 5 years ago and continuing today, compared to GDP, the measure of economic activity, is 375%.
Holy
so there's
cow.
much more debt in the economy today than there was at the beginning of the Great Depression. So I saw that there would be a great need for bankruptcy practice, and I'd gone to Harvard Law School and practiced law, primarily tax and corporate law in Manhattan for a number of years, but I didn't know anything about bankruptcy. So I went back to school and got a Master's of Law degree, an LLM degree in bankruptcy at St. John's University. And my background is unusual for a bankruptcy lawyer because in addition to my legal knowledge and experience, I have significant business experience. I have an MBA from Columbia University, and I was an investment banker for a decade doing corporate finance for emerging market companies, where I took companies public. I did some junk bond financing and some M&A work.
I saw that you ran a firm or did something. You're president and COO of Sandberg and Sikorsky?
Well, that was a jewelry manufacturing company that was in financial distress when I came in, and I managed the turnaround of that company to make it one of the most profitable jewelry manufacturers in the United States. And after that, I was an entrepreneur. I started a business in Danbury called Sellers Market. So in my bankruptcy practice today, I bring a perspective of someone who understands the legal side, someone who understands the finance side, and someone who understands the operations side of business, which is an important perspective when you're renegotiating debt.
Okay, what is bankruptcy? It's like the fundamental question. You know, it's not what it used to be because they reformed it about 10 years ago. I remember there was like a reform. It wasn't going to be where you got totally wiped out, but I guess it's still quite a bit of assets or liabilities get wiped out in a bankruptcy, so to speak.
Right. Well, bankruptcy is a legal process whereby individuals and businesses who can't pay their debts get a fresh start. So bankruptcy is provided for in the U.S. Constitution, and cases are administered by federal courts. And when someone files for bankruptcy, an automatic stay is put into place that prevents creditors from trying to collect the debt. And the bankruptcy process is designed to make sure that all creditors are treated equally. And in part of bankruptcy, depending on the kind of bankruptcy, the debts will either be completely discharged or restructured. The bankruptcy laws did change significantly in 2005, which made it a little bit more difficult for people to file and a lot more difficult to practice bankruptcy law. There's a lot more requirements on bankruptcy lawyers than there used to be.
Okay, they got an extra 6 months or a year of study and that kind of thing? And
Well, there are all sorts of provisions. Bankruptcy lawyers are the only lawyers that have to disclose their fees. Bankruptcy lawyers are the only lawyers that have to assert that their clients are disclosing things accurately and truthfully. So there's a higher level of disclosure on bankruptcy lawyers than any other kind of lawyer.
okay. And why do people seek protection? Is it a simple thing as there's just too many debts compared to assets, or there isn't any hope that they're ever going to get rid of the liabilities that they have?
Well, most people want to pay their debts. And what happens is most people's debts are incurred prudently, but then something unusual or unexpected happens.
Like a medical situation?
Right. In 95% of the cases, either a medical situation, a job loss, or a divorce happens, and it makes it impossible to pay the debt that people expected to be able to pay. And people approach bankruptcy reluctantly. There's a stigma of failure.
Yeah.
That keeps people from looking at bankruptcy. It's not an issue for corporations. General Motors, Chrysler filed for bankruptcy. No one seemed to care. But for individuals want to pay their debts. They're reluctant to give them up. If we had colored ribbons and marches for people with unmanageable debt, there'd be a lot more people filing for bankruptcy.
So you could say the people from certain countries, there's traditional countries, Eastern Europeans, some Italians, I can't say all Italians, but it depends on the background, really have that stigma thing where other nationalities, oh well, right?
In my practice, almost every client who comes in does so reluctantly and really wants to pay their debts, but something happened and they can't.
And what are the benefits? Let's put it this way. Let's say you got a typical person that has a house, a car, but just too many credit card debts. Let's say he's got $50,000 of credit card debts, and he had one of the aboves, or maybe he had two out of the three. He had a medical situation that gave him another $30,000 of debt, and then he had a divorce. So there were two good incomes coming in. Now there's only one coming in, and someone like that usually a candidate, or
absolutely. So
yeah.
The benefits of bankruptcy is, first, it stops creditors from bothering you. Most people come to me after they can't deal with the phone calls and letters from creditors that are upsetting. So first thing, you file bankruptcy, those harassing contacts from creditors stop. The next thing that happens, if people are being garnished, if their wages are being taken to pay creditors, that stops. If you're in the middle of a foreclosure, if you haven't made mortgage payments, you're in the middle of foreclosure, that stops. And it's possible to keep a house, particularly by filing Chapter 13. I'm sure we'll get to that later. And then if you have too much debt, if that's unmanageable, it's possible to reduce or eliminate that debt in bankruptcy. So those are enormously powerful benefits. And compared to what happens if you don't file for bankruptcy, if you have credit card debt that you can't pay, creditors will go to court, they'll get a judgment against you, and with that judgment they can seize a bank account, they can garnish your wages, or they can put a lien against your house. So bankruptcy offers enormous benefits for most people.
Okay, I was going to say, what specific debts, we were talking in the green room before we came in, what specific debts can be handled versus what can't?
Okay. Well, again, it depends on the nature of the bankruptcy, the chapter you're in,
right.
But most people file in Chapter 7. So in a Chapter 7 bankruptcy, most unsecured debts, credit card debts, medical bills, are eliminated completely. Debts that you can't discharge include student loans. In this district, Connecticut and New York, where I practice, you literally have to be in a coma to discharge student loan debt. It's much easier to restructure student loan debt outside of bankruptcy than inside of bankruptcy. So student loan debt, non-dischargeable. Other big non-dischargeable debts include domestic support obligations, alimony and child support. and recent income taxes and recent personal property taxes are not dischargeable. But if the tax years are more than 3 years old, so we're looking at tax years before 2010, it's possible, if you meet a long list of hurdles, to discharge some tax debt.
That's the kind of stuff they put in when they reformed it.
Yes, they made it a little bit more difficult to discharge debt in 2005.
But there is some of that can be, okay. And then you were talking about if you got a car, obviously you can't get rid of the
right.
You can't get rid of the raw loan on the car that you have because they can take the property back.
It's very difficult to modify secured loans with collateral, so a mortgage or a car loan typically. In Chapter 11, to a lesser extent Chapter 13, it's possible to modify some of those debts if businesses can more easily modify secured debts. But for a typical individual in Chapter 7, if you continue to pay the home loan or car loan, you can keep your house, you can keep your car. If you stop paying your mortgage or your car loan, you will lose the car or house.
You're mentioning chapters, and I never really asked this question before. I mean, I never had a bankruptcy attorney before me either. But are they all relevant, 1 to 13, or are some the ones that actually do something, and the others are just like counseling chapters?
No, they're all relevant. They're all for different kinds of bankruptcy.
Okay, so like Chapter 1 is for...
There's no Chapter 1.
There isn't any, okay.
The main chapters are 7, 13, and 11. Don't ask me why they use gambling numbers.
Okay.
But there's also a chapter for foreign bankruptcies. There's a chapter, Chapter 9, for municipal bankruptcies. Detroit recently went through a municipal bankruptcy. And there's Chapter 12 for family farmers and fishermen. I've yet to see a family farmer or fisherman in bankruptcy. I'm looking forward to that.
I guess they were fishing for that type of person to come forward, but they wanted to say, hey, we're taking care of you. Yeah, I guess. What terrible things happened? Well, we covered that pretty much.
Well, let's talk a little bit more about the bankruptcy chapters.
Yeah, okay.
So there's Chapter 7. That's a bankruptcy chapter that most individuals will use.
Right.
And in Chapter 7, your unsecured debt, credit card debt, medical debt, is eliminated. And you get to keep 100% of your income going forward. So that's a very good deal. And the cost of doing that, besides the legal fees, we'll get there.
We can't get, because of Comcast rules, we can't mention a specific number.
All right, we won't mention. But
okay.
In addition to legal fees, you can only keep assets that are exempt in Chapter 7. So exempt assets are assets that by either federal law or state law you can keep. And both federal and state statutes have lists of things you can keep because we don't want people to go through bankruptcy and be destitute. So you're allowed to keep a certain amount of equity in a house. You're allowed to keep a certain amount of equity in a car. Certain amount of whole life insurance. You're allowed to keep virtually all of your home furnishings and all of your clothes. You can keep a certain amount of jewelry. So as part of the introductory consultation, we look to see what kind of assets you have. And most of my clients in Chapter 7 keep all of their assets. They keep their house, they keep the car, they keep their business assets. They keep everything because the exemptions generally are generous enough for you to keep things. So Chapter 7 ends up being remarkable. You get to eliminate all of your unsecured debt, you keep 100% of your income going forward, and you keep all of your assets. That's a pretty good deal. So the law limits the people who can take advantage of that, and you have to qualify for Chapter 7. And you qualify first by being below median income. And median income is the halfway point of income, and it's based on household size.
It goes by state.
It goes by state and it goes by household size. So in Connecticut, a household of 1, if you're living by yourself and your gross income is below now just under $60,000, you get to go to Chapter 7. For a household of 4, The median income in Connecticut is about $107,000. In New York State, those numbers are about 20% lower. But if your gross income is calculated in bankruptcy world, and that calculation is a little odd, but if your gross income is below that median income threshold, you get to go to Chapter 7. If your income is above that threshold, then the second pathway to Chapter 7 is you get to pass the means test, or the mean test, because it can be very mean. And the means test is an objective test where we start off with your actual gross income, and then we apply largely fake deductions, which the IRS has determined are appropriate for food, clothing, and shelter for people who live in a particular county. And then if you have income left after your real gross income and the fake deductions, if you have no gross income left, then you go to Chapter 7. If you do have gross income left, then you go to Chapter 13. So Chapter 7 is the fastest, quickest, best form of bankruptcy if you qualify. If you
11 is for corporations?
We'll get there.
Okay.
If you
All right.
if you don't qualify for Chapter 7 because your income is too high, or you may have too many assets that are exempt. It's unusual. You might have a plane you want to keep. It's hard to keep a plane. But if you...
I would think that would be hard, right?
It's hard to keep a plane. I had a...
But if you're involved in dusting, you dust out west, and...
That's possible.
Yeah, you can keep it.
But if you have assets that are, slightly above exemption levels and you want to keep them, then Chapter 13 is appropriate. So Chapter 13 is a debt consolidation plan, similar to consolidation plans you hear advertised, only Chapter 13 is not a scam. And the idea of 13 is we take all the debts and we pay usually a portion of them based on your income. And the means test determines how much of your income will be used to pay creditors. Creditors are paid over 3 to 5 years in Chapter 13. Chapter 13 is really useful if you've lost income and you've fallen behind on a mortgage. So you're in arrears on your mortgage, but you've gotten your job back. You can suddenly make up that arrearage and you can be current on your mortgage. And we can use Chapter 13 to stop the foreclosure and help you keep your house. It's not terribly useful for much else. But there's a unusual quirk in 13 where if you have an underwater second mortgage, we can strip that off in 13, but that's complicated. So that's Chapter 13. You have to qualify for 13. You have to have regular income. And there are debt limits, which are sometimes a problem in Fairfield County. You can only have around $1 million of secured assets and only about $350,000 of unsecured assets. Those numbers sound high, but if you have a large home in Fairfield County, you can be ineligible for Chapter 13. Then you get to go to Chapter 11. So Chapter 11 was designed for large corporate reorganizations, Chrysler, General Motors, Hostess,
and wealthier individuals.
and individuals with high income and a lot of debt. So individuals can use Chapter 11 if you don't qualify for Chapter 13, or there may be strategic reasons why Chapter 11 is better. I will put individuals into Chapter 11. So 11 is a much more complicated bankruptcy because creditors get to vote in Chapter 11. So you propose a plan, and you have to propose a plan that creditors will like, so they vote in favor of your plan.
This is with the proper counsel like yourself.
Yes.
You come up with the plan, then you go in and you present it on a given day when everybody's there.
Well, you send it off to your creditors, and sometimes you call and beg and grovel for their votes.
Okay. I thought it was like a meeting or something.
Well, ultimately, there's a confirmation date in court, and creditors usually vote in advance. So usually you have the votes, but it's possible that not all creditors will have voted for a plan, and then you go to court and you try to cram down a plan over the objection of some creditors. It's possible to do that in Chapter 11.
Interesting. When is the proper time for a person to consider, or let's say a person that's out there listening to us now, I'm thinking about this. What would be the deciding factor? Just too many phone calls and just too much debt? Is there a certain amount versus income that or is really it depends on an individual. Well, there's a guy that's making $100,000 a year, he has $200,000 of debt, and he's just sick of the whole rat race because he doesn't know if he's going to keep that level of income down the road, but it hasn't happened yet. Is that a guy to consider it? Or
yeah, absolutely. If you're an individual and you're only making minimum credit card payments, you're a very good candidate for bankruptcy, because most credit card debt runs at interest rates over 20%. So if you're only making minimum payments, it's unlikely you'll ever make much of a debt on the credit card payments. If you expect some change in your economic circumstances in the immediate future that allow you to make more than minimum credit card payments, then maybe you don't have to consider filing. But for people who are only making minimum payments, yes, those are people who should consider filing. A lot of people come in who are just tired of calls from credit card companies or collectors. I have clients who essentially are judgment proof. They're older people, they're on Social Security. Creditors can't reach Social Security. They may not have very many, if any, assets, but they're still tired of being called by credit card companies, so they'll file for bankruptcy just to stop that.
Then there's this other stigma of, well, you know, once you file bankruptcy, it takes 7 years or more before you're back on your feet. And that was the shocking thing when I heard you speak, that credit scores can be recovering the next year. If you're you keep one card or something and you're making payments on a regular basis and you're making your car payments on a regular basis, then the very next year you have a recovery in your credit scores.
Or it may be faster. I have lots of clients whose credit scores improve the moment they file for bankruptcy. Well, how could that be? If you've missed a mortgage payment, if you've missed significant credit card payments, you're probably having a credit score in the low 500s. Once you file for bankruptcy and the debt is subsequently discharged, that debt's eliminated. And you can't file again, Chapter 7 to Chapter 7, for 8 years. So after you file for bankruptcy, you are a very good credit. Your debt's been wiped out. You can't file again for 8 years. So you're economically a very good credit, and there are creditors who understand that. So most of my clients are solicited for credit cards immediately after they file. Typically, at first, they're secured credit cards, which operate like debit cards. You put money in a bank account.
You put 500 or 1,000 or whatever.
And that's your credit limit.
And then you use that up, and they see that you're using it judiciously.
So you
and then they up
use
the ante.
The cards, and then after a year, the security is released, and then gradually, as your income increases and you've shown that you can responsibly use credit cards, your credit limits are raised. So most of my clients' credit scores increase immediately upon filing, but all my clients, if they follow rules that are actually on my website for rebuilding credit after bankruptcy, all of the clients can improve their credit scores certainly within a year of filing for bankruptcy.
Right. Now, what gambling debts are, well, I got the question here. Are they can't get it out, dischargeable?
Gambling debts are dischargeable in bankruptcy. You have to be a little bit careful. If you have casino markers from Las Vegas, it may be a felony not to pay those. So we won't discuss casino markers from Las Vegas, but casino markers from Atlantic City or from casinos in Connecticut can be discharged. The issue with those debts are whether they were incurred with an intent to repay them. So that's in bankruptcy, they're incurred fraudulently. If you have no intent to repay the debt when you incur it, those debts are not dischargeable. So the issue with casino markers is whether you intended to pay the gambling debt when you incurred it. And I've had 2 bankruptcy clients recently with debts, casino marker debts in excess of $150,000. Now you may think it's impossible to repay casino markers of $150,000. But in both cases, they were individuals who regularly gambled, who regularly lost and repaid their debts, and regularly won and went back and gambled.
There was back and forth,
right.
because there was a reasonable expectation on the part of the creditor that you were going to pay him back.
Right. So the creditor extended credit because those were very good clients who always paid their debts, and the debtor reasonably intended to repay it. So those are the kind of gambling debts that can be discharged.
Okay. There's also stigma about who can find out about this bankruptcy filing and whether or not it can hurt them with the employers and neighbors and that kind of thing.
Right. People typically are reluctant to file because they're afraid that their neighbors or their employers will find out that they filed for bankruptcy. And that's usually not the case. Bankruptcy is, in a sense, a public filing, but only lawyers who have access to the filing system can actually see the petition. You would have to go to the bankruptcy court and get through the court security to view a bankruptcy petition, and that's highly unusual. Bankruptcy petitions are not available to be seen on Google. Most individuals, no one will ever know that you filed. If you owe your employer or your neighbor's money, they'll receive a notice in the mail. But as long as you don't owe your employer or your neighbor's money, there's no reason why they would find out. And local newspapers don't report individual Chapter 7 or Chapter 13 filings. There are some websites that accumulate information on Chapter 11 filings for business. I've had clients who we've done searches and discovered that, but for individuals in 7 or 13, usually no one will ever know.
Yeah, now how does the process go? We got about 1 minute left.
The process. It's relatively quick for Chapter 7, longer for Chapter 11. So it starts off with an initial consultation where I give you advice whether it makes sense to file for bankruptcy, and then what chapter, what's the most appropriate chapter for you. We collect information, and based on the information we collect, we prepare bankruptcy documents. Then for Chapter 7, clients never go to court, they never see a judge. They just have what's called a meeting of creditors, and most creditors don't show up. And then a few months pass in Chapter 7 and they get their discharge. In 13, after the meeting of creditors, you have to confirm a plan. In Chapter 11, it's a more complicated confirmation process.
They're waving to me, so that means it's time to go.
Thank you very much
for coming on the show. I want to thank the viewers for tuning in to Community Forum. Tune in next week, same time, same station, and we'll have another interesting program. Good night for now, and see you then.